people work for who they are paid by. You can contact me, Phil, at PolarisFinancialPlanning.com, or listen to the cleverly titled The Phil Ferguson Show. Each show, we have an interesting investing skeptically topic and an interview with someone fighting to end religion. Polaris also gives 10% of gross revenue to support the growing secular movement. You're not just getting better investments, you're helping to change the world. All right, everybody. Once again, I had to modify what I expected to do on the show this week because we had something so cool and fun come up. So next week, we will have on Anthony Magnabosco, and he's going to talk about street epistemology and how just by asking people questions and getting them to think about what they believe, you can help people think more clearly and give up superstitious and crazy beliefs, including religion. But today, we have Amanda Knief, and she's been doing a lot of posts about Supreme Court rulings and court rulings, and she's also an attorney and works for the American Atheists. And I thought, oh my God, Amanda, you should totally, oh my God, be on my show. And she said yes. So Amanda, how are you?
I'm great. Thank you for having me. I love to talk about Supreme Court and legal stuff, so this is really exciting.
Well, it was just funny because I've been reading your stories, and you've had quite a few adventures in the last couple of days about court things. And, of course, you do live in D.C., right?
I do.
Oh, of course, I had 2 extra days there before the Reason Rally where I went and saw the mall and the museums and took the Robert Ingersoll tour. Just a wonderful city. Absolutely amazing.
I love living here. I do. Not just for how beautiful it is and everything, but it's exciting to live here. There's always something happening, whether it's a protest or a parade or something. It's a really fun place to live.
Well, before we get too into the court cases, and actually I want to start, if you don't mind, with something a little not quite national, but the Mississippi ruling. But I don't know if you heard that Mike Huckabee has been ordered by a court to pay Survivor $25,000 for illegally playing Eye of the Tiger at the Kim Davis rally.
That's awesome.
So he acknowledged that he was going to pay it in court, and then he decided to deny that he had to pay it, saying that it was a religious event. And the attorney for Survivor pointed out, well, if it's a religious event, then you're guilty of fraud on your filings with the election commission, Federal Election Commission, because there you claimed it was an event for your political campaign. And so he had to withdraw his claim that it was a religious thing, which is weird because apparently you can play whatever music you want if you're a religion. They get to break all the laws. So now Mike Huckabee is trying to figure out how to pay $25,000 because apparently the guy is almost broke.
Running for president does not make you rich, apparently.
Well, it makes some people rich, like Donald Trump, but that's not what we're here for today. But this Mississippi court case, well, what happened there?
Okay, so after we got marriage equality from the Supreme Court, not every state was happy about this. And so in Mississippi, they passed a law, and part of this law, it's called HB 1523, allowed county clerks to recuse themselves from issuing marriage licenses based on their religious beliefs. So basically what it was trying to do is get around marriage equality. And it was aimed at LGBT marriages, but it could have been for any reason. If 2 people came in and they were mixed race, if they weren't the right religion and the people knew it, they could have refused anybody for any religious reason. And so this was challenged. And today, it would have gone into effect on July 1st, so that would have been Friday. And the court said that this is a way to end around marriage equality and that it was not enforceable. And so he has put a stop to it. The judge said no. And so you can't do it. You can't use religion to get out of issuing a license.
Well, and I like to say, if you are not comfortable with one of the aspects of your job, find a new job.
Well, if you're a government worker, you work for the government, and you don't have the same rights as everybody else. Unfortunately, that's just true. I mean, it's true if you work for a private employer, too. you do lose some of your rights, and one of them is that you represent the government, you don't represent yourself, and you have to treat everyone equally according to the law, and your religion doesn't come into it. It's why we don't allow taxi cab drivers to deny people service. It's why we don't allow restaurants to deny people services based on their religious beliefs. And why would we allow someone who works for the government to pick and choose who they're going to provide services to? The government does not get to discriminate.
I'm all for it. So that only affects that district, though?
It only affects, well, it was only a Mississippi law. It was a state law. But they challenged it in federal court, obviously, because they felt it was unconstitutional based on the ruling, the marriage equality ruling. And so many times when you have a federal ruling or constitutional precedent and you have a state law that you think is violating that, you go to federal court. Federal courts then have jurisdiction if it's constitutional, and you are often better faring, whereas state courts tend to favor state laws. So it vacates the Mississippi law, and it applies to Mississippi.
Yay! So now, of course, the Supreme Court has come out with a handful of rulings, and we talked about this before the show for the listeners. They don't know this. And there's at least 3 of them that we can talk about, maybe more. And the one that I know the least about, and so I'm going to have you do that next, and we'll tease the listeners with the other juicy ones. You mentioned a corruption case. What's that all about?
So if you're at all familiar with Virginia, then you probably know about this case. This is Bob McDonnell, and he was actually the Virginia governor, was thought to be a possible vice presidential candidate back when Mitt Romney was running, and he was convicted in federal court of graft, of bribery. There was a guy who had this pill supplement, and he paid for the governor's daughter's wedding. He let him drive a brand new car. He got a fancy watch. The governor's wife was also convicted. And basically, it was just this ongoing, for months at a time, list of money and favors and expenses that this man, this entrepreneur, dumped on the McDonald's while they were in office, seemingly in return for favors. And the McDonald's had appealed to the appeals court, which had upheld their convictions. And so they appealed to the Supreme Court. And unanimously, the Supreme Court vacated the conviction. And the Mrs. McDonald's conviction was, they had stayed a decision pending the outcome of her husband's, so I believe hers will also be vacated. And they sent it back down to the appeals court based on what they said, and it was Supreme Court Justice, or I should say Chief Justice Roberts writing the opinion. What they did is they narrowed the definition of what can be defined as corruption. And it has to be a formal and concrete government action. So the governor would have had to actually file a lawsuit or sponsored a bill or take an administrative action so that, if he's just asking underlings to take a look at something, or if he's introducing people or sponsoring this guy at a party, it's supposed to give a lot more leeway to free speech, so that even if somebody is showering money on a politician, unless the politician, the elected official, public official, takes concrete action through government work, bribery cannot be pursued. So the appeals court will now have to determine whether any of the actions the prosecutor was looking at meet this new definition.
Now I'm a layperson, but that sounds like a load of crap. Am I missing something?
I disagree heavily with this, but from a free speech point of view, and because we have the definition of money as free speech, what they're trying, and I'm playing devil's advocate, I don't necessarily agree with this, but what they're trying to do is that you don't want, for example, you could say that because the NRA gave a lot of money to senators and members of the House of Representatives, and then because they didn't take a vote on gun legislation, perhaps that was bribery. We don't want that, apparently, as a country, is what the justices are saying. We want concrete action. So we don't want it so that if you are an elected official and someone gives you a lot of money and you introduce them to people or you tell people that you support them, that's free speech, and that's one of the benefits of being in office, or one of the burdens of being in office, because you have to have money to run for office. And what they're trying to say is that there's still plenty of room for prosecutors to go after elected officials or public officials, and they're just trying to make it more concrete, that it can't just, so they're trying to make it so it's not so flim-flam. But personally, I think our elected officials should be held to a much higher standard, and that you shouldn't necessarily benefit from being in elected office, that it's supposed to be a higher goal.
Yeah, you're a public servant.
Yes, and there's plenty of ways to benefit after you get done. And so I think that this probably went in the wrong direction if we're trying to clean up our system, but that is not the job of the Supreme Court. The job of the Supreme Court is to rule on what's in front of it, not to be aspirational. And it was unanimous,
wow.
Which says something. When you get Sotomayor and Kagan and Breyer and Ginsburg, who are extremely liberal justices, and all to agree with, Alito and Thomas, then, they're the experts, and I'm not on this. But I also lived through it, living down here, and saw what was happening, and so I wouldn't say that I'm the most impartial person either.
Right. Now, a little bit off the topics, and I didn't warn you about this, it just popped into my head, so brace yourself. What do you think about this whole 8 Supreme Court justice thing and the Congress not wanting to even consider Obama's appointment?
Okay, so just from a practical standpoint, having 8 justices is not a good idea because you can get split decisions. And that is not good because it means that you get a split decision just upholds the lower court decision. And it's basically a wash, and you don't want that. There's nothing special about having 9 justices. We could have 7, we could have 5, we could have 11. 9 is just the way it's been for several decades. So I don't care necessarily about the number, other than the fact that 4-4 is a bad idea. So make it odd so that, we can have our majority opinions. Now, I think that it is complete bullshit that we are not getting a vote. I don't care whether it's this nominee or not, and I'm not particularly concerned about whether he gets in or not. I'm concerned about the precedent this sets for process. I find it extremely disrespectful and contemptuous of the public, of the Constitution, of their offices, that the people who are in power on the Judiciary Committee will not have a vote. They don't have to approve him. They can vote no.
Right.
But they have this silly idea that by not even having a vote, they are somehow giving their advice. And so that sets a new precedent. And that changes the way we've been doing things for about 100 years. And I'm not sure they want to go down that road. And they keep throwing out this thing about how Biden said we should do this back when Kennedy was being nominated or something.
Yeah, talk to me about that, because I've had that thrown in my